Tom. Why don't we start by hearing from you on how you started in the carbon finance business or prototype carbon fund as it was at that time?
Sure. Well, my name's Tom Duval, retired from the bank, formerly chief counsel in the legal department, headed up a unit, had various names. I guess the last name when I was there was the Project Finance and Guarantees Unit. And it dealt with a number of different subject matters, all having to do in one way or another with the bank's involvement with some external form of finance, not IDA or not raising money in the capital markets, but other forms of finance, primarily trust funds. You know, the bank, ever since I guess the 50s or 60s, has been in the business of establishing trust funds where donors provided grant financing essentially to the bank to finance a particular activity. And the bank acted as trustee for those funds and was pretty much, there were essentially two types of trust funds. One that funded the bank's own activities, economic and sector work, and another when we were acting as sort of an intermediary between a donor and a recipient country to pass on grant funds to them. And then along came Ken Newcomb and various other folks who had this idea about carbon finance. And at the time, when I was originally involved with this, I guess the work was headed up by the environment unit within the legal department. But it quickly became clear that a lot of the more legal aspects connected with the carbon finance business fell more into my bailiwick. So that's when I was asked to get involved with the team that was working with you and Ken and others on establishing the prototype carbon fund. And it was really a team that consisted of folks from the environmental unit, David Freestone, who had a much greater background than I did in understanding what climate change was all about and the regulatory framework for that. And then there was also Scott White, who was the, I guess he was the Deputy General Counsel at the time, but he had been working in the finance unit of the legal department, which worked a lot more with private sector sources of finance than I had been accustomed to in the trust fund business, where we were dealing mainly with official donors. But my background, similar to Scott's, had been in a law firm working in the capital markets area. So a lot of my background lent myself to fitting in quite nicely with the work we were doing on establishing the prototype carbon fund, which raised a number of innovative legal issues for the bank, and we can talk about that if you'd like.
Yeah. No, certainly. I mean, that must have been a totally new area of business because till then the bank was mostly involved, as you said, with grant financing through trust funds. But this was related to the Kyoto Protocol. So what were the key challenges, or how was it very different from what the bank was accustomed to, and what were the challenges and opportunities created by the fund?
Well, I think there were at least two main areas of challenges. One, as far as I recall anyway, this was the first trust fund where you didn't really have contributors who were providing grant financing, but you had entities that were expecting some sort of asset back in return for their, I'm not sure I want to call them contributions, but in return for the funds that they made available to the prototype carbon fund. So that broke new ground in the bank. The second area that was significantly different from our normal trust fund business was the participants in the carbon fund were a combination of governments as well as private sector entities. So we were taking in money from both governments, but particularly from private sector entities, which raised more legal issues, and then using it to acquire assets on their behalf, which they could then use to meet their regulatory obligations under the Kyoto Protocol, or in theory, they could just monetize the assets and sell them in the market if they wanted. So those were the two main issues. The other issues that it raised from a legal perspective was, what exactly is this? It wasn't your normal trust fund. So we were quite concerned about a number of aspects, but the main aspect we were concerned about is whether this raised any particular regulatory concerns, because you could conceivably view the arrangements we were putting in place as the bank either brokering or underwriting securities. And therefore we had to look at the question of whether or not this activity raised any regulatory concerns in the jurisdictions here in the U.S. where the bank was located, but also in the jurisdictions where we were marketing potential interest in the carbon fund. So we looked at the regulatory environment in a number of jurisdictions, primarily in the U.S., although we consulted external counsel in other jurisdictions. And it wasn't quite clear whether these were securities or not securities. We were receiving somewhat, I wouldn't say conflicting advice on it, but we weren't getting clear answers on that. So we ended up structuring the fund in a way that could be viewed as not violating U.S. securities laws if these things were deemed to be securities, by structuring it in a way that satisfied the private placement exemption under the Securities Act of 1933. That was one issue that we spent a lot of time on. The other concerns that we had were what the repercussions would be for the bank's own line of business by virtue of the contracting we would have for the purchase of emission reductions, because we were largely buying them from member countries or state-owned enterprises in member countries. And of course the bank has a lending relationship with these countries. So one of the issues that we had to consider was, if there was a problem under an emission reductions purchase agreement that we entered into for a carbon fund, what implications that would have for the bank's own lending activities. One thing that was quite clear is that we wanted to keep them separate, and we didn't want to find ourselves in a situation where, if there was a default under an ERPA, that then would result in the bank being expected to take some action with respect to its own loans to the government. So we made quite clear with the participants that there wasn't going to be a cross-default clause that would be triggered, that we reserved our right to act in our own interest under our loans, which is, raised an issue there because as a trustee we had a fiduciary obligation to act in the best interest of the participants in the fund. On the one hand, at the same time we have our own interest as a lender. So we were quite concerned about that. There were also issues about taxation as to whether or not, since all the funds that were contributed by the participants were held in a trust fund at the bank, whether it would be appropriate to use the bank's privileges and immunities to shield the participants from any tax liability that they otherwise might be subject to when they receive these assets that we acquired on their behalf. So there were a lot of novel issues there that took a while to sort through.
Yeah, I remember the time where we would go into discussions with you and your team for the full day. One of my earliest recollection is in your offices you would settle down as if with all your food and your snacks looking as if you were going to be there for hours, which was often the case, I remember. In terms of the work with regard to setting off the fund, I think a lot of the things were related to the bank's own articles and the regulatory environment in which we were placed. What are the major challenges in putting together the contracts with the member countries?
Well, on
and the ARPAs.
On the purchase side or on the money coming in side, or both?
Both actually.
Well, on setting up the fund, I think and in terms of the contracts we had with the participants in the fund, those that were providing the resources, there, I think it was primarily, well, two main issues. One, governance, how this fund was actually going to be structured, and what the bank's roles and responsibilities were going to be, and what rights the participants had in terms of project selection. Because traditionally, the bank didn't want to sort of cede that control to providers of funds. Bank had its own policies and procedures, but here we were sort of operating in an area where there weren't a lot of policies and procedures that applied, given the somewhat novel nature of the activities. So a lot of the issues related around what rights the participants would have in the governance of the fund. And particularly challenging since you had both governments and private sector companies who didn't necessarily have the same interest. So that was certainly something that took up a lot of time. The other issue that concerned us was dealing with the conflicts that I mentioned in terms of making sure that addressing the issue of liability. What was the bank's liability if these projects didn't work out correctly, and what were the participants' liability between themselves if one participant defaulted in its payment obligations. What implications that had for the other contributors. Don't remember exactly how we addressed that, but certainly those were issues that we spent a lot of time looking at. And in the end, we could draw on a lot of precedents, because I guess the best way to view the arrangement between the participants is it really was like a partnership. And the bank, in some respects, was acting as agent for the participants when we actually contracted the emission reductions on their behalf. So we drew a lot on partnership agreements that exist in the private sector. Didn't have those in the bank because the bank had never engaged in that type of activity. So that's where we drew a lot of our precedents from. Then on the contracting side, with the sellers of the emission reductions, again, we didn't have a lot to draw on there because the bank had never entered into those kind of contracts. But we looked at, in some respects, obviously the terms and conditions we have on our loans and tried to adapt those, but also we drew again on a lot of private sector precedents in terms of asset purchase agreements. And that was something that the team that had worked primarily in the private sector before was quite helpful in guiding us on. And then we had to deal with all the regulatory aspects of the Kyoto Protocol, which at the time, and probably still are, somewhat of a mystery to me, because here you are, you're acquiring an asset that by definition was something that didn't exist. It was a reduction from a base case, so it's kind of hard to wrap your mind around exactly what you were acquiring. And then there were all the issues about how you actually conveyed title of these assets to the participants, and we were relying essentially on the registries to do that. And I guess we set this up before the Kyoto Protocol actually came into effect, right? Which also posed some issues. Not only were we buying something that didn't exist, but it hadn't even been recognized legally from a regulatory perspective. So people were taking a big leap of faith when they set this up.
And I remember the early contracts had us acquiring title for everything related to that activity, just to
make sure
cover our bases. The way it was worded seemed to convey a lot of discomfort to those who you were trying to explain, because you were basically saying that anything related to the activities that are being undertaken would belong to the bank or the trust fund or the prototype carbon fund. So then there were yet another set of issues around the client countries, our member countries, in terms of their regulatory framework, their approval, the host country.
Oh, yeah.
What were the key challenges there, if you recall?
Well, I think, again, it was sort of the fact that this was new ground for people and they didn't quite know what the regime was for how the country, well, there was this whole question of what the country owned and what the participants owned, right? And so that was a lot of internal challenges that the countries themselves had to sort out, as I recall.
And in the context of the environment within the institution, what were the main challenges? I think certainly there was within the legal framework itself and the lack of any precedent, I think.
I think that was the main challenge institutionally as well. I mean, the bank is a somewhat risk-averse institution, and which was probably, and it had its own policies and procedures. So I think from the challenge in setting it up was the bank didn't know what to do with it, right? Didn't really fit into any line of business that the bank was engaged in. And at this point, the Kyoto Protocol hadn't come into effect. So I think there was a lot of skepticism on the part of management as to whether this made any sense for the bank to get engaged in it or not. But on the good side was, since it didn't really fit into any rules or regulations or policies that the bank had in place, that was a good thing, because then you weren't bound by those policies, rules, and regulations, and it was quite helpful in that respect in terms of getting approvals to set this up. Wasn't easy, and I'm not sure today that if the bank was looking at this, that the bank necessarily would have leapt in as it did there. I think it was in part the force of personalities that were able to get this through. It was quite an achievement.
And those personalities, were they at the highest level in the form of Jim Wolfenson, and at the operational level at the level of Ken Newcomb? Or,
well, I was thinking more Ken, and was it Ian? Was he the vice president then?
I think Ian was the vice president, yes.
So I think Ken was, as far as I could tell, and at this point it was more David Freestone who was working with Ken than I was. He was able to drive this through. You really need a champion like that at the bank who, A, knows what he's talking about, but B, can sort of have the vision to see how this could fit in with the bank to be able to move it through. And he was quite successful at that. Wasn't that easy, but he got it through.
And in the bank, as you know it today, would something like that be feasible, or it's more
I don't think so. I think the bank has become more risk averse. I mean, I'm not that close to the bank anymore, but that's just the sense I have, that it's not, it doesn't think as much outside the box as it used to. Could be wrong.
And in the climate change space, those were days where climate change was considered probably a niche activity, only a few engaged in. In terms of the overall, the range of activities under climate change and number of people involved, it's more or less mainstream now. What is your view on that?
Again, I'm just not that close enough to have a view. But even if it's been mainstreamed, it's not so much in the finance space or the carbon finance or the asset development states. It's more just the traditional bank work as far as I see it from the outside, but I could be wrong.
Okay. Now, going back again to the challenges at that point of time, I recall a lot of back and forth with the private sector participants in trying to understand the legal framework within which the World Bank operated, the concept of international law, the concept of undefined jurisdictions. What were the key issues at that point, and how did the private sector come around accepting the framework, or how did the bank adapt in some sense to some of the demands?
I'm not sure, because I was going to go, I didn't have the time to go back and look
Okay.
and see how we dealt with that agreement. But so those agreements were governed, they didn't have a governing law.
They didn't have a governing law, they were international law.
Well, that was because of the involvement of governments. I mean, you couldn't have
Okay.
a facility where you had agreements with, since it was a joint venture between governments and the private sector, you couldn't have a situation where half of the agreements were governed by international law and the other agreements were governed by some domestic law. But, again, I think it was probably somewhat of a leap of faith on the private sector part as well. And they weren't really that exposed to that much of a risk because, after all, they either got the assets or they didn't. And they were in it, I think at that point they were in it not really for the value of the emission reductions, but for being part of the process of learning by doing and trying to put in place a product that would ultimately allow for the transfer and sale of emission reductions. So it was really a pilot experience on their part. They weren't driven as much by monetary or legal considerations, I think, as they obviously had to satisfy their own internal approval processes, but it was more a leap of faith.
And if I remember correctly, most of them were just trying to understand the framework and rather than object to it. In terms of the evolution from the prototype carbon fund to, say, the umbrella carbon facility, which was much more of a commercial in nature in terms of the size and the objectives. What do you recall with regard to how the evolution took place, or were there many changes that were needed?
Not from a legal perspective, I don't think so. No.
No, okay.
The legal format really didn't change much from fund to fund.
Yeah, the move from the initial ERPAs, which used to be customized according to transactions, to the time you and your team put together the general conditions, and that made it much simpler, is my recollection, right?
Sure, because then you don't have to negotiate every provision. And since and it just provides a more uniform treatment from both the purchaser perspective and the seller perspective, which is the way the bank tends to deal with its own lending operations as well. We try and treat everyone the same.
And again, in all the years, were there any major issues that have come up with regard to the enforcement? You talked a little bit about the interests of the bank as a lender versus trustee. Did these come up, and how were they handled?
I don't recall any situations where it came up. The only situation that I recall was in the HFC 23 deals where the business people wanted to sign the emission reduction purchase agreement before we'd actually receive the commitments from the participants.
And what in your recollection was unique about the HFC deal, other than the size? Was there something specific?
No, it was really just the size, I think. There were big deals, obviously. And so from a legal perspective, I found it somewhat odd that the bank could commit as trustee to acquire emission reductions when it didn't have
the money,
the agreements with the participants in place. But it all worked out.
Yeah, it worked out in the end. But I have to say that in my mind, the umbrella carbon facility, the HFC deal, was the first form of seller representation in some sense. You had prepared an asset, and then you were going into a market and get commitments from the buyers, as opposed to most of the other carbon funds where you put together the fund, as you say, they put together the fund and then go and look for transactions.
Yeah.
That isn't that a more natural form of the World Bank engaging in the carbon market of
Which
trying
one?
to find the assets, prepare it, and then go and look for the buyer?
Well, except for the fact that if you do that, the bank is then taking a risk that it wouldn't find the buyers. And then what happens?
But shouldn't there be, or isn't there ways to address that? Primarily, the expectation is the biggest issue, no? The reputational risk.
Well, and the cost issue, right?
And the cost. Who pays for the cost?
Right.
And that at that time, if you remember, the thinking was that the brokerage fee, if you will, from the HFC transaction, which amounted to about $30 million of brokerage fee, was intended to move the bank in the direction of covering the cost. And if the cost issue is dealt with and the expectation, would that be a natural evolution of the bank's role with less conflict?
I don't know whether it has less conflict. I could certainly see the bank going down that road. And then, but you're envisioning a situation where there wouldn't necessarily be a fund that would acquire these assets. You would just then act as you're really acting as a broker, I suppose, and then you find willing purchasers. It's a different line of business for the bank, for sure. Whether that's something the bank would want to engage in or not. It's a riskier endeavor because of the reputational risk, and then you do have to figure out some way to cover the cost if you're not able to recoup those costs because you don't have anyone to sell the assets to. I'm not sure whether, I doubt it would raise any articles concerns, but it's a different line of business for the bank.
And the umbrella carbon facility was something similar, that once you've identified the buyers, you do get them to contribute to a trust fund kind of a structure through actual commitments or bank guarantees or promissory notes. So I suppose that could be. But looking back over the years, what do you think were the major achievement of the bank in the context of the carbon business? What did it do well, and what could it have done differently or better?
Well, I don't know about the latter. I think the major achievement was just demonstrating. Obviously, the purpose of the Prototype Carbon Fund was to demonstrate how these things might work and to support the CDM and the JR markets, and I think it was successful in that. But it was intended to be a prototype. It wasn't intended to be replicated into a lot of different funds, and then the bank moved more into the business of setting up funds for individual countries. I don't know in retrospect that that was the kind of thing that the bank had a comparative advantage in doing, and I think it also contributed a little bit to fragmentation because you had a lot of different funds out there with not a lot of money that were trying to chase a bunch of projects. So would the bank have been better off if it had simply left it at the Prototype Carbon Fund and then found some other vehicle for, but the market really didn't take off that much. I guess that was the problem. We were thinking that it would, and it didn't for a variety of reasons, including the fact that the price collapse, which I guess was due to I'm not sure why it collapsed. It was no demand or too much supply or some combination of the two. So
if you recall, what happened was between 2000 and about 2004-05, the price was gradually going up to around 4.5. Then the HFC transaction in December 2005, where we agreed on a €6 price, which kind of all of a sudden broke that €6 mark, and then the prices kept going up almost till over €20 under the ETS till about 2010, and then the famous cliff that Ken kept talking about. I think I attribute that cliff to Ken talking about it again and again and again to scare everybody into going off that cliff in 2012. So around 2011, everybody expected us to go off the cliff, and the market collapsed, and the Lehman Brothers happened, and the European economies started slowing down, and everything put together, the prices started collapsing in 2011. But I think the interesting part that you brought up, which I hadn't thought of for a while, was a lot of the country funds chasing the same number of projects, and a fair amount of concern from at least the country funds on the allocation of projects across. And I remember we went through a 6 to 9 months of consultation. That was a concern at that time, right?
Yes.
And I think one of the major things that we had happened to the overall business was the thinking that we would be doing World Bank projects, and we ended up doing third-party projects. And how do you think that kind of affected the overall standardization of the business and the risk associated with it?
I don't know that it had much of an effect on that. I think it more raised the questions of, why is the bank doing this? Or would it not have been more sensible, assuming that the prototype carbon fund demonstrated, which it did, that this thing could work? Why wasn't this just put in some other institution outside the bank? What value added did the bank have at that point if these weren't associated with World Bank projects?
And till about 2005, I mean, there's logic for the bank to be involved. I think following 2005, when Kyoto Protocol got ratified, I think when the large number of hedge funds started coming up in London and started transacting, at that point it became, I think, complicated for the bank to continue to justify its engagement. Do you recall any specific kind of changes taking place in the overall business around that time, or it was business as usual?
I don't.
Okay, yeah. So, are there any other thoughts you have on how potentially the bank could have done things differently?
No, other than what I mentioned, is to
get out of the business.
Well, or I don't know about get out of the business. Yeah, not necessarily that it had to be totally disassociated with that, but whether housing it within a series of trust funds in the bank was really the best way to do it. Maybe it was, but maybe there could have been different ways of doing it as well. And then could you have set up a separate legal entity of some type that would have been able to take over that role? I don't know.
And was there a model of that kind of a legal entity? The CRIF, the risk insurance facility at one point was viewed as a kind of a model, or
was it? But that was that a separate legal entity that was set up? I can't remember. Talking about the Caribbean Catastrophic Risk Insurance Facility. Yeah. But it wouldn't have been difficult to do. Or if you're dealing, and then IFC, of course, set up its own funds as well, right? So you had this whole proliferation of funds across the institution, and it's just difficult to figure out how they all related to each other. Sort of like all the various climate funds that the bank has set up. They seem to just result in a lot of fragmentation.
Okay. And again, from the perspective of the overall environment, you feel that we are in a much riskier environment, from a risk-averse environment as far as the management is concerned. But in terms of the enabling environment for the bank itself, from our clients and partners, is there a higher expectation in your mind, or? No.
Just not close enough to have a feeling for that.
Okay. Any other thoughts before we close?
No.
Okay.
Thank you.
Thank you.